Okay, folks, we're back here. So we've covered what the statute provides and what you can recover. I want to talk next about how the process works. These cases under the Surface Transportation Assistance Act's whistleblower provisions are not filed in a regular court. They are filed with OSHA, which is the Occupational Safety Administration, which is part of the United States Department of Labor. You do not want to file with a state OSHA. You don't file them with the DOT. If you file with them, they won't do anything with it. You file with OSHA, any OSHA office. If you file in Washington, if you're employed in Washington, you can file in Seattle or St. Louis or wherever, preferably the Seattle office of OSHA. And you can find their offices online at osha.gov. You have 180 days to file your complaint with OSHA. If it's 181, you're done. You have no case. If it's 210 days, you've got no case. You have 180 days from the date of the adverse employment action. If you have been blacklisted on DAC and you suspect you've been blacklisted on DAC, you have 180 days till you discover, until you have clear and unequivocal knowledge of what's on your DAC report. That precedent was decided in a case we handled called Cantor versus Maverick Transportation. But other than DAC reports, if you've been fired and you don't know for sure the reason why you got fired, you still only have 180 days from the date of the firing to make your filing with OSHA. Your filing with OSHA has to be in writing. It can be an email, it can be handwritten, it can be a fax, but it has to be in writing. That is a requirement of the statute. So here's what's going to happen. You file your complaint with OSHA. If you file it on your own or we file it for you, it goes to OSHA. OSHA will assign a case number and will assign an investigator to investigate your complaint. Now, here's the bad news. It's going to take a while, and you're probably going to lose at OSHA. We have done approximately, in 22 plus years, approximately 1,200 cases with OSHA. And I believe we've won about 25 times. Now, that's not the end. Under some whistleblower statutes it is, and that's why we don't practice in this area. Essentially, to win at OSHA, you got to win with the OSHA investigator, and OSHA is sort of like the EEO to these whistleblower complaints. OSHA is sort of like the counterpart of EEOC is on sexual harassment, sexual discrimination, race, age, disability discrimination, etc. So you got to go through there. It's just simply required. OSHA assigns an investigator. Typically, that OSHA investigator is going to send the complaint to the other side, to your former employer, and they're going to be given the opportunity to give a position statement, and you will be given an opportunity to submit a rebuttal, either in writing or orally, depending on what the investigator does. But the real issue here is not with the investigators, because essentially it's my belief to win that you have to win with the OSHA investigator, the investigator supervisor called the regional supervisory investigator, the assistant regional administrator of OSHA, the Office of Whistleblower Protection Programs of OSHA in Washington, and the Office of the Solicitor, which is, think of them as the in-house law firm for OSHA. But the one good thing OSHA does is it sort of smokes the employer out and commits them to a position statement in writing. So it's pretty tough for them to change their mind later. They are locked in, and if it's a lie, then often we can prove it to be a lie. Now, OSHA moves at different speeds around the country. In California, you might be at OSHA 3 years. In Texas, it might be 3 months. In New York, New Jersey, it might be 3 years. Atlanta or Chicago, it might be a year. Some of those regions of OSHA allows you to say, please make a ruling now and don't finish your investigation, which is in essence begging for a dismissal. And that's okay in these cases, because what OSHA does doesn't have any bearing when you go the next level up at the Department of Labor. So I know that sounds a little complicated, but you go to OSHA, you lose there, you can request a loss essentially. Sometimes OSHA will work to settle the case, in fact often, But if you lose at OSHA, you have 30 days to appeal and request an administrative law judge of the Department of Labor to hold a hearing, basically a trial without a jury. All federal agencies have administrative law judges. For example, Social Security Administration has administrative law judges who have hearings to determine whether or not somebody is disabled within the meaning of the Social Security Act. The National Transportation Safety Board has administrative law judges. DOT has administrative law judges who determine whether or not fines should be levied against a carrier, and things of that nature. Department of Agriculture has administrative law judges. At the Department of Labor, there are about 38 administrative law judges. And the good thing here is a little different than a regular federal judge in that these judges are specialized. There are 22 whistleblower statutes similar to the STAA. They know whistleblower law. So they have people who have seen lots of truck driver cases, whistleblower cases for railroad workers, airline pilots, etc. They know whistleblower law, and they know health and safety law. And almost all of them are very good judges at the Department of Labor. So once we get past that OSHA hurdle, and it's not really a hurdle, we can automatically go past it. It's just a time crunch. Then we get a judge assigned. We have 30 days to appeal, and the judge will hold a hearing. He will get the parties together on the phone. He'll schedule a hearing date and set deadlines for doing a whole lot of things, like taking depositions, exchanging documents. And then we have a hearing, which is essentially a trial. The judges are not in every city of the country. They're in Boston, Philadelphia area, Newport News, Virginia, Washington, D.C., Pittsburgh, Cincinnati, and San Francisco, and New Orleans. And so a judge will typically fly in or drive in. If we're in Louisville, Kentucky, we'll probably end up with a Cincinnati judge. If we're in Denver, it's typically serviced by the San Francisco judges. And a judge comes in and you present your case. I don't want to say it's completely informal, but it's a lot less formal, depending on the judge, than a regular federal court case. And they're good judges. And then after the hearing, we submit a written closing argument called a brief. I usually put a lot of hours into that, but you can do it too if you represent yourself. And then the judge issues a decision. After the judge issues a decision, either party has 15 days to appeal to what's called the Administrative Review Board. Think of it as like an appeals court for the Department of Labor. And that appeals can take a year or two, more typically 2, and then after that it can go into a federal court appeal. Now, I don't bring this up for purposes of scaring you away. Just understand, if you bring one of these whistleblower cases under the Surface Transportation Assistance Act, and it goes in, the employer wants to fight all the way, or the former employer, all the way as far as you can get, you're going to be in it for a while. Now the good thing is that about 90% of the cases settle. I know a lot of people talk about settlements. We shouldn't plea bargain when it comes to criminal cases. People shouldn't settle. I don't want to settle. Well, if there were no settlements in the court system in this country, criminal, administrative like we're doing here, Department of Labor, Social Security disputed cases, civil cases, personal injury, you wouldn't be to trial for about 30 years. So the good news here is that the Department of Labor employs a full-time mediator who will sit and try to get the parties to settle. And most cases do settle, and when it comes down to trucking companies looking to pay real money, they'll do it. That's a little bit of the overview of the process. You need to be in it for the long run, but you're probably not going to be in it for the long run. But you've got to be prepared to go